For more reaction, let's talk to Advocate Paul Hoffman, the Accountability Director. Good morning to you, Advocate Hoffman. The verdict is out. The ConCourt has dismissed Mkhwebane's appeal against the Bancorp cost order. What did you make of that outcome?
Good morning, Mbo, and good morning to your viewers as well. It seems to me that the Constitutional Court has now painted the Public Protector into a very tight corner. Not only is she irrevocably on the hook for the costs of, or the share of the costs of the Reserve Bank in the matter heard today, she is staring down the barrel of several matters in which she will be asked to pay costs out of her own pocket again, because she has not changed her way of running her office in any manner since the bad experience that she had in January 2017, which is just after she started in her new post as Public Protector. Not only is her reputation in tatters, her finances in disarray because of the prospect of having to pay huge amounts of legal costs once they are determined and taxed. The Law Society or the Legal Practice Council or the Bar will take an interest in her fitness to be an advocate at all because of the finding that she has misled a court. It's a capital offense for an advocate to mislead a court. And so one can expect that the Legal Practice Council will inquire into this finding and determine whether she should be disbarred as an advocate, which will obviously have an effect on her ability to continue in the office she holds.
Advocate, we know that her conduct was criticized quite heavily in the litigation, including how she submitted falsehoods to the court. You speak here about being disbarred as an advocate. Considering how her conduct came under so much scrutiny, what process will need to take place? Should she be disbarred in the legal aspect of things, and also looking at the impeachment process of a public protector?
Yes, they're two different processes. Parliament is responsible for the impeachment process. The courts are the forum in which her fitness to be an advocate will be determined once an inquiry by the Legal Practice Council has been held. Now, the difficulty in this particular case is that Parliament received a complaint from Accountability Now back in January 2017, complaining that there was a lack of competence and a lack of integrity in the way in which this very same inquiry, the Absa Lifeboat inquiry it's usually called, was conducted by her. And what we have is a situation in which, had she been held to account by Parliament apropos of the complaint made in January 2017, she would not have been rolling around like a loose cannon in the Chapter 9 institutions of South Africa ever since. The Parliament has a lot to answer for its failure to respond to the complaint about the conduct of the Public Protector. But if Parliament chooses not to do its work, then it is up to the Legal Practice Council to involve itself in an inquiry into her integrity as a professional advocate. Because if she lacks integrity, she cannot possibly continue in that office and won't be allowed to if she is disbarred.
You speak about lacking integrity, Advocate Hoffman, and we know that this morning the Constitutional Court agreed with the High Court when it came to how she was unlawful. She didn't understand her constitutional duty to be impartial. When we speak about impartiality in the legal atmosphere, especially an advocate of her caliber, what does that really trickle down to when it speaks to her office as a credible office?
Yes, the office is required by the Constitution to act without fear, favor, or prejudice, which really means independently, and to be impartial. Those are constitutional requirements laid down for her. And she has been found wanting again and again in this regard. There's all of the Pravin Gordhan litigation. There is the review that the president is going to bring in relation to her finding last Friday. And she's in big trouble with the horse racing industry, where she gave remedial action requiring Parliament to pass legislation, which Parliament has no constitutional power to pass. The horse racing industry is an industry that is governed at provincial level, not at national level. So the findings, which relate only to what happened in the Absa Lifeboat matter, are being vindicated over and again by what has been going on ever since, because of her incompetence and her lack of integrity in the way in which she has run her office.
She, the public protector, when questions were posed to her by some reporters regarding some of the content of what was unveiled by Justice Kampepe, she said that she's denied and dismissed that she told falsehoods under oath, and she's also insisting that she acted in good faith. But what was consistent is that she wants to be given the opportunity to study the judgment. What processes will take place after she's studied this judgment? What happens there?
When she has studied the judgment and she has taken advice, which will be to the effect that the judgment is final and that the finding that she has acted without integrity, that she has lied under oath, that she has not brought an impartial mind to bear on the issues before her, she ought then to really reconsider her position as public protector. If she withdraws the reports that are the subject of litigation at the moment, she might be able to spare herself some adverse costs awards. But if she carries straight on in the way that she has done up till now, she can expect that the courts will lose patience with her again, and that bigger and more onerous costs awards will be made against her when her activities are found wanting, as has been the case thus far.
Thank you so much for your time, Advocate Hoffman. Thank you for your reaction there to the findings of the Constitutional Court regarding the Public Protector. Of course, we'll continue to bring you more, just breaking down the elements of the breaking news. Stay tuned.